Marian Holt was 32 years old on the morning her sister handed her a key and called it an inheritance. The key was old, iron, slightly rusted, the kind that had sat in a drawer for years and been forgotten and found and forgotten again. Constance held it out across the solicitor's desk with the particular expression she had always reserved for moments when she was performing generosity rather than practicing it. A kind of gentle, preemptive pity, as though she were already sorry for whatever Marian was about to feel. Their father had been dead for 3 weeks. The will had been read an hour earlier, in the same room, and Marian had sat through it with her hands folded and listened to everything their father had built across 40 years. The house, the farm, the savings, the lease on the 2 cottages on the eastern lane, pass entirely to Constance. Marian received the old library building on the market square, 2 stories of limestone, its windows boarded since the Reading Society had folded a decade ago, its interior unvisited and unventilated, accumulating the slow damage of an empty building in an English town. "You always loved books," Constance said. She said it warmly, which was worse in its way than saying it coldly. Marian took the key. As she did, she noticed the solicitor, old Mr. Farrow, who had handled their father's affairs for 20 years and who was standing rather than sitting, as he had been throughout the reading of a will he had not prepared, look briefly and involuntarily at the key in Marian's hand, and then look away. It was a small movement, barely a second, the kind of thing a person not paying close attention would not have noticed. Marian had spent 4 years in a notary's office learning to watch the people in a room as carefully as the documents on the table. She noted what she had seen, said nothing, and put the key into her coat pocket. Marian had worked at the offices of Holt and Pennock, notaries, in Ipswich from the age of 24 until her father's health had begun to fail 3 years ago, and he had written to ask if she would come home to Suffolk. She had gone without hesitation. She had spent the 3 years since managing the household while her father gradually became less capable of managing himself, a responsibility that had suited her practical temperament and that she had performed without resentment, because she had loved her father genuinely and because the alternative was leaving him to Constance, who visited often and managed nothing. At Holt and Pennock, she had spent 4 years copying and filing the instruments that governed the transfer of property and the disposition of estates. Wills, in particular, she had handled scores of them, from the simple to the bitterly disputed, and she had learned the language of a properly executed testament with the same familiarity that a carpenter develops for the grain of the timber. She knew what a valid will required: 2 witnesses present at the moment of signing, both of whom had observed the testator sign and had then signed themselves in his presence, with the date and place recorded in the instrument, and the testator's signature consistent with his established hand. She also knew the signs that suggested a document had been prepared under pressure, or signed by someone whose judgment was impaired, or altered after the event. These were not dramatic signs. They were small, technical, the kind that a person trained to look for them noticed, and a person not so trained generally did not. Mr. Pennock had told her once that the most important skill in probate work was not legal knowledge but attention, the ability to read a document and notice what was absent as clearly as what was present. She had also learned, across 4 years of watching disputes resolve themselves in the offices of solicitors and notaries, that the people who lost inheritance cases were almost always the people who had not read the document carefully enough, or had not found the document at all. A will cannot speak if no one has found it. A right cannot be claimed if no one knows it exists. The most significant thing in a probate dispute was usually not the law, but the paper, which document existed, where it had been made, and whether anyone had been in a position to locate it and understand what it said. She had thought about this more than once in the 3 weeks since her father's death, and particularly in connection with Mr. Farrow's expression when she had picked up the key. The will that Constance had presented, through her own solicitor, a man named Rutter whom Marian had not previously encountered, had been executed 2 years before their father's death, during a period when his health had begun its first significant decline, and Constance had been visiting the house with increasing frequency. The document had been prepared by a firm in Bury St. Edmunds, rather than by Farrow, who had handled every other legal matter in their father's adult life. Marian noted this without comment when she examined the will in the solicitor's office. She also noted that the 2 witnesses named in the attestation clause were individuals she did not recognize, not local people, not family connections, but names she could not place. She wrote them in her notebook alongside the date and the Bury St. Edmunds firm's name, and said nothing to anyone. She went to see Farrow the following morning. He was a careful man who had been practicing in the town for 40 years and who chose his words with the deliberateness of someone who understood the professional consequences of speaking carelessly. He said that the will was, to his knowledge, validly executed. Marian asked if he had prepared it. He said he had not. She asked whether he had advised her father in the period leading up to its execution. He was quiet for a moment longer than a simple negative would have required. Then he said that her father had visited his office approximately 6 months before his death, not before the Bury St. Edmunds will was made, but after. He had come in without an appointment and had asked Farrow to explain the process by which a man might amend or entirely replace an existing will. Farrow had explained the requirements in full. A new instrument, clearly dated, revoking all previous wills, executed before 2 witnesses who were present together at the moment of signing. Their father had listened carefully and had then said that he would handle the matter himself, because there were elements of it he preferred to keep private for the time being. He had said he had people in mind who could serve as witnesses. He had thanked Farrow and left. He had not returned. Farrow was looking at his desk rather than at Marian, as he said the last of this, in the manner of a man who has been waiting for someone to ask him a specific question and who is relieved, and also somewhat unsettled, that the question has finally arrived. Marian wrote down everything he had told her, closed her notebook, thanked him, and went out into the April street. She stood on the pavement for a moment and thought about what her father would have needed if he had wanted to replace a will without involving Farrow, without Constance's knowledge, and without leaving any document in the house that Constance had spent a week clearing and organizing after his death. He would have needed privacy, and a place where Constance would not look, and 2 witnesses he trusted who were not family. And he would have needed somewhere to keep the finished document where it would survive until it was needed, a place that was his, that had always been his, that Constance had never thought worth examining closely. She thought about the library. She thought about the archive room behind the librarian's desk, with its separate and older lock. She thought about the key Constance had handed her, iron, rusted, the kind of key that had not been cut recently, and about whether the front door of a building that had been closed for 10 years would have developed that much corrosion on a key that had sat unused indoors, or whether the corrosion suggested a key that had spent time in a different kind of place entirely. She thought about Farrow's glance when she had picked it up, and then she thought about what her father might have done with a small brass key if he had needed to ensure it went with the building and not with the house. Then she walked to the market square. The library stood at the northern end, a 2-story limestone building constructed in 1829 with money subscribed by 12 of the town's leading families, of whom the Holts had been one. It had functioned as a reading room, lending library, and occasional meeting place for nearly 30 years before the Reading Society's subscriptions had declined and the building had been quietly closed. The boards on the windows were weathered now, gray and slightly warped at the edges, the nails showing rust stains down the limestone below them. A carved stone lintel above the door read, "Reading Room and Library," in letters that had lost most of their definition to 30 years of Suffolk weather. Marian's key opened the front door. Inside, the particular smell of a building that has been sealed too long, cold stone and damp paper, and the faint, sweet mustiness of old wood beginning to give way. The entrance hall was narrow, with a tiled floor and plaster walls beginning to separate at the ceiling line. To the left, the main lending room, its shelves still holding several hundred volumes, some upright, some fallen sideways, several swollen with damp along their spines. To the right, the reading room, with its 4 long tables, 2 of the table legs broken, debris accumulated against the far wall. The librarian's desk stood at the back of the entrance hall, still holding a loans ledger open at the last page of entries before the building closed. And behind the desk, a narrow door, set slightly deeper into the wall than the others, with a sign above it painted directly onto the plaster. Archive. The lock was not the same as the front door's lock. It was heavier, older, a different mechanism entirely, the lock of a door fitted at a different time by someone who wanted it to hold. Marian's key did not fit it. She had suspected it would not, but she tried it anyway, because she had learned at Holt and Pennock that confirmation was always better than assumption. She stood in front of the archive door for some time. Then she went to find Mr. Webb. Albert Webb had been the library's caretaker for its last 8 years of operation and had continued to look in on the building occasionally in the decade since it closed. Out of habit, and because nobody had officially told him to stop. He was about 60, with the careful and unhurried manner of someone who had spent decades keeping track of other people's things and had never lost anything important. She found him in his garden, 2 streets from the library, and asked if she could speak with him. He said he had the afternoon. She asked him about the archive room. He said her father had used it as a private working space during the last years the library was open. He had still been a trustee, and the archive held the society's original documents as well as some older papers from the building's early history. He had kept his own key to the archive, separate from the building key, and had carried it on his person at all times rather than leaving it in the building. When their father had been taken ill and brought to hospital, Webb said that key had not been among the personal effects. He had assumed it was somewhere in the house. He had not asked Constance about it, because he had not known what to ask. Marian asked where her father's personal belongings had been kept during the period of the house clearance. Webb said that some items had been brought to the library. Constance had directed several boxes and the contents of a wardrobe to the building, apparently intending to collect or sort them later, and apparently not having done so. Marian thanked him and went directly back to the library. The boxes were behind the librarian's desk, 3 of them, labeled in Constance's handwriting with the date of the clearance, and propped against the wall beside them, wrapped in a cotton cloth, her father's winter coat. The heavy wool coat she had watched him wear to church every Sunday of her childhood, the collar frayed at the left edge in the way it had always been frayed, the right pocket still carrying the faint impression of the folded handkerchief he had kept there habitually. She lifted it from the cloth. She went through both outer pockets, empty. Then she felt along the lining, working from the shoulders down to the lower panels, pressing her fingers between the wool and the silk, in the methodical way she had searched for things before. In the lower section of the left inner panel, beneath the original lining, her fingers found something hard and small. The stitching there was different. She could feel the slight ridge where a seam had been opened and then re-sewn, not by a tailor, but with the neat, deliberate stitching of someone working carefully alone. She used the small scissors from her bag to open the seam. The key fell into her palm, small and brass, less corroded than the iron key, a newer cutting. She knew, before she tried it, that it would fit the archive lock. It did. The archive room was perhaps 12 feet by 10, its shelves holding 30 years of Reading Society administration, bound volumes of minutes, financial accounts, correspondence with booksellers and publishers. On the lowest shelf of the far wall, laid flat rather than filed upright, was a folded document in a cream-colored sleeve. Marian carried it to the entrance hall, where the light from the boarded windows was better than the darkness of the archive. She set it on the librarian's desk and opened the sleeve. It was a will. 4 pages, in her father's own handwriting, rather than a copying clerk's. She recognized the hand immediately, the particular formation of his capital letters, the slight backward lean of his script that she had known since childhood. The date at the top of the first page was 4 months before his death. She read the operative clause with the careful attention that 4 years at a notary's office had made instinctive. I revoke all former wills and testamentary dispositions and declare this to be my last will and testament. Then the disposition, the farm to be divided equally between my daughters Marian Holt and Constance Holt, in equal shares. The house and its contents to Constance. The library building and its contents to Marian, free of any charge or encumbrance. 2 signatures at the foot of the final page, below her father's. Albert Webb, his address written clearly beside his name, and below that, Eleanor Crane, schoolmistress, with the same detail. Both signed and dated the same day as the will. The attestation clause confirmed that both had witnessed the testator sign in their presence, and had then signed themselves. Marian read the will twice, from beginning to end. She read the attestation clause a 3rd time. Then she sat in the half-dark of the empty library and held the document in both hands and thought about everything she knew about what made a testamentary instrument valid, and what made one supersede another, and how a will made 4 months before a man's death compared in law to a will made 2 years before it. She went to see Webb and Miss Crane that same afternoon, separately, showing each of them the will without the other present, and asking each to tell her in their own words what they remembered of the day it was signed. Their accounts agreed in every particular. A Thursday morning in autumn, Webb said, he recalled the light through the library windows and the smell of the morning air, and the fact that her father had arrived precisely at 9 o'clock, carrying the document folded inside a leather wallet. He had asked Webb to read it through before anything else. Webb had done so. Her father had then called Miss Crane in from the reading room, where she had been returning books to the shelves, and had asked her to read it also. When both had finished reading, her father had sat at the librarian's desk, unfolded the document, and signed it in their full view. They had each then signed below his signature, in his presence and in each other's presence, as the attestation clause required. He had been entirely himself throughout, deliberate, clear in his intentions, unhurried. He had told Miss Crane, before she signed, that he was making the will to ensure that both his daughters were equally provided for after his death, and that he had chosen not to involve a solicitor because he wished the matter to remain private until it was no longer possible for it to be undone. He had thanked them both. He had walked home and, Miss Crane had observed from the library steps, had stopped at the corner of the market square to speak with the butcher, and had looked, she said, more settled in himself than he had done in several months. Marian returned to Faro with the second will that same evening. He read it in full before he spoke. He said it appeared to him valid on its face, properly dated, the revocation clause correctly drafted, the attestation in order. Being more recent than the Bury St. Edmunds document by nearly 18 months, it would supersede that instrument entirely if admitted to probate. He said he was glad she had found it. He said it in a way that suggested he had been hoping someone would. She went to see Mr. Garvey the following morning, a solicitor of 60 who had practiced in the town for 30 years and who read the will, the attestation clause, and the summary of what Webb and Miss Crane had told her, with the unhurried steadiness of someone who has seen every variety of family dispute and learned, over decades, to identify which cases could be won and which could not. He said the case was sound. He said the likely challenge would be a claim of testamentary incapacity, that their father's mental faculties had been insufficient at the time of execution to make a valid will, which was a common response to disputed probate applications, and one that sometimes succeeded when the evidence for capacity was thin. He said the evidence here was not thin. Webb and Miss Crane were credible witnesses whose accounts were detailed and consistent. Their father's own handwriting was throughout the document and could be compared against other authenticated samples. The medical records would be relevant. He named his fee. It was more than Marian had available. He looked at the will for a moment, and then at her, and said he would defer his payment until after the estate was settled, because he had practiced law for 30 years, and he preferred to be paid from a case he had won. Constance received notice of the probate application within the week through Rudder, who filed a formal response within 10 days. Their father's mental capacity at the time of the second will's execution was contested, given the state of his health and the absence of professional supervision during the document's preparation. She communicated with Marian exclusively through Rudder for the remainder of the proceedings, and did not write directly. Marian read this as advice from Rudder that she was following, and concluded that Rudder had told her the direct approach was unlikely to help her position. She drew her own conclusions from that inference and returned to her work. She spent the following weeks building the evidence that Garvey would present. She obtained her father's medical records from Dr. Marsh, who had treated him through the final 2 years of his life. The records for the specific month the second will had been signed showed no notation of significant confusion, no new medication affecting judgment, and no consultation about diminished capacity. She found 2 further witnesses beyond Webb and Miss Crane who had spent time with her father during that period and whose recollections were consistent. He had been in declining health but in possession of himself. She prepared a sequential written account of the entire matter: the Bury St. Edmunds will, Pharaoh's account of her father's visit, the execution of the second will, the months of deliberate silence that followed, the key in the coat lining, the archive room, with every fact supported by a named source and every date confirmed by a document. She wrote it in the form Holt and Pennock had taught her: clear, linear, nothing asserted that the evidence did not support. The probate hearing was held in the county court on a morning in July, in a room that smelled of old paper and linseed oil, and the accumulated formality of many previous hearings. Marian sat beside Garvey at one table. Constance sat beside Rudder at another, in a dress Marian did not recognize, which told its own story about what the months since the first will was read had provided. They did not look at each other. Marian had the second will and her sequential account of the evidence on the table in front of her, and she kept her hands still and her attention on each speaker as they were called. Garvey opened with the document, its date, its revocation clause, the disposition of the farm, and the attestation. He called Webb first. Webb described the Thursday morning with the unhurried precision of a man who had been thinking about little else for some time, and who intended to be perfectly clear. Her father had arrived at 9 o'clock with the document inside a leather wallet. He had asked Webb to read it before anything else, and then had called Miss Crane in from the other room and asked her to read it also. When both had finished, her father had sat at the librarian's desk and signed the document in their full and unobstructed view. They had each then signed below his name in his presence and each other's. He had been entirely in possession of himself throughout. He had made a remark about the quality of the morning light through the archive room window. He had thanked them both and walked home, and had stopped on the corner to speak with the butcher, and had looked, to Webb's eye, as settled as he had seemed in a considerable time. Miss Crane's evidence agreed with Webb's in every particular. She added that their father had explained to her, before asking her to sign, exactly why he was making the will, what it contained, and why he had not engaged a solicitor to prepare it. He had said he did not want Constance to know the document existed until it had already been properly executed and put somewhere safe. Miss Crane had understood what he meant, and had signed, because she had believed then and believed now that it was the right thing to do. Rudder, for Constance, argued the informality of the instrument and the state of the testator's health. He called no medical witness, because Dr. Marsh had declined to provide evidence inconsistent with his own records, and because Marian's written summary of those records, which Garvey had provided to Rutter in advance, made the medical position clear. Rutter argued that the absence of a supervising solicitor raised questions about the reliability of the process. Garvey noted that the law required no solicitor to be present at the execution of a will, and that the statutory requirements, a testator of sound mind signing in the simultaneous presence of two witnesses who then signed in his presence, had been fully observed. The instrument was in the testator's own established hand. The date was correct. The witnesses were credible and uncontradicted. The judge asked Rutter one question: did his client have any positive evidence, medical, testimonial, or documentary, that the testator lacked testamentary capacity at the moment of execution? Rutter said the circumstances surrounding the will's making gave reasonable cause for inquiry. The judge said that was not an answer to the question he had asked, wrote something on his papers with the calm deliberateness of a man who has heard this kind of non-answer before and knows precisely what it signifies, and the essential substance of the hearing was concluded. The formal arguments continued for another hour in the manner that legal proceedings continue when their outcome has already been determined. The written decision arrived 2 weeks later. The second will was admitted to probate as the valid last will and testament of their father. The farm was to be divided equally between Marian and Constance. The house went to Constance as specified. The library went to Marian, free of any charge or encumbrance. The judge further noted that the mortgage Constance and Mr. Aldwych had taken against their portion of the farm did not affect Marian's share, since no co-owner may encumber the whole of a jointly held property without the knowledge and consent of all co-owners, and Marian had given no such consent. Constance did not write to Marian after the judgment was delivered. Marian had not expected her to, and had not written first. The practical matters, the farm's division, the valuation, the appointment of a manager for Marian's portion, were handled through solicitors on both sides with the business-like efficiency of people who have decided that direct communication is inadvisable. Marian found the arrangement suited her. She had a great deal of work to do. The library occupied most of her attention through the autumn and into the winter. A local carpenter assessed and repaired the shelving. The work took 2 weeks, during which Marian worked alongside him where she could, holding and positioning while he fitted and fixed, because it was faster that way, and because she had discovered, over the past months, that she preferred being useful to being supervised. A glazier restored the windows once the boards came down, and for the first time in a decade, the interior received natural light, gray Suffolk autumn light, filtering through glass that was not entirely clean, but was glass rather than timber, which made the whole enterprise feel suddenly real. A charwoman from the village spent 3 weeks on the cleaning, working systematically from the archive outward, and by the end of it the building smelled of beeswax and cold stone and something underneath that might have been the particular smell of old paper returning to life in dry air. Books beyond salvage were carefully removed and recorded before disposal. Those that could be dried and cleaned returned to the shelves in order. Several local families, hearing from the carpenter and the glazier what was happening in the old library, brought donations. In the first week the doors were open, volumes from attics and spare rooms that had been accumulating for years, which were more useful on a public reading room shelf than where they were. By November, the library was open 3 mornings each week, with Marian present throughout. Miss Crane occupied the reading room on 2 of those mornings to give reading lessons to the children of families who could not afford the church school's fees, an arrangement that had not been planned in advance but had come about over a conversation on the library steps and had seemed, to both women, the obvious thing once it was proposed. It cost Marian nothing beyond the wood for the stove, and it filled the reading room on the mornings that might otherwise have been quiet, which she had not anticipated and which she found she was glad of. Mr. Garvey's fee was paid in September from the first quarter's rent on her portion of the farm, which was being managed by a local tenant on terms that Garvey had helped her negotiate and which were fair to both sides. Webb declined any financial acknowledgement for his role in the proceedings, saying he had only confirmed what was true, which was the minimum a man could reasonably do when asked. Marian thanked him in a different way, by asking if he would be willing to come in on the open mornings and help readers find what they were looking for on the shelves, a role he accepted without ceremony and performed with the unhurried patience of someone who had spent 30 years keeping track of exactly where things were. The second will was framed and hung on the wall of the archive room, which had become Marian's private office, her desk under the window, her notebooks on the shelf above it, the ledger for the library's income and outgoings open beside them. Beside the frame, on a small shelf, she had placed the brass key from her father's coat lining. And beside the key, folded carefully in its cotton cloth, the coat itself, because she could not bring herself to give it away, and because it seemed to belong here, in the room where the thing her father had sewn into its lining had finally found its way to the light. There is something in Marian's story that I find myself returning to again long after the telling is done. It is the image of her father in the last months of his life, sitting alone in the archive room of a building no one else visited, writing out in his own hand the document he hoped would eventually set things right, and then sewing it into a coat lining and leaving the coat somewhere a person who was looking for it would find it. He could not know who would come or when. He could only make the trail clear enough and specific enough for the right person to follow. Marian had been that person, not because she was lucky, but because she had spent 4 years in a notary's office learning to notice what a solicitor's glance toward a key might mean, and because she had read every document she had ever been given carefully and all the way to the final line, and because she had gone back for the coat. If that kind of story is one you return to when the day is done, I would very much welcome you among the listeners here. There is a subscribe button nearby, and pressing it costs nothing and means the next story will find you when it comes. And if you would like to leave a comment, I would be glad to know. At what moment did you first suspect the coat? Because I believe you suspected it before Marian went back for it. And I would like to know if I am right. Thank you for listening. I will see you in the next story.